So the question I wanted to address today is whether a smart contract is tantamount to a legally binding contract. And it's important to note that just because it is called a smart contract does not mean it's in fact a contract that you can enforce in court or in any sort of jurisdiction. The key thing is this: you have got two sets of people on this side of this debate. You have the natural language, contractual people who believe smart contracts should encapsulate all of the language that you would find in a written contract, a traditional contract. On the other side, you have the people who believe that a smart contract, which is really just a snippet of code along the blockchain, is really just digitizing a business process. So you've got two conflicting views on it, right? And there's a couple things to consider. First of all, digital signatures are not universally accepted. We've got laws here in the United States that say, a digital signature is good as a regular signature on a written contract. Not all jurisdictions are the same. At the same time, even here in the United States, you have things like the statute of frauds and other things which are exceptions or could be exceptions to digital signatures, such as transfer in real estate or transfers in excess of a certain amount of money, and each state has their own law. So you have that to contend with. The other thing is specificity and ambiguity, right? An ambiguous contract is not enforceable. And so when you're talking about, especially in the ICO context, an agreement to terms and conditions, a subscription agreement, which I espouse, even the SAFT, which I have my issues with, but it's an agreement, that is an absolute necessity, because in the absence of those specific terms, you have great ambiguity, and an ambiguity in a contract is not enforceable. So you have an issue there which you really have to contend with, because if there aren't terms that have been pre-negotiated in a sense and agreed to with both parties, there's nothing to enforce. Thirdly, you have scenarios where you've got these permissionless distributed ledgers, right? And so the question becomes, who is really the counterparty to your smart contract or your legally binding contract? And there just really isn't one in that case, right? You have nobody to enforce that contract to. There's no particular terms and conditions that are binding on any party. And so the question becomes, who do you sue? Who's the defendant? Who have you actually dealt with, right? And you see that, especially in the larger crypto coins, that you just do not have an actual counterparty to a contract, because everything is automatic in the sense that it's a permissionless ledger. Finally, the big issue, and this is sort of a topic for another time, but there's very little law that describes or defines what your digital asset is, right? So you're talking about an ICO token, whatever it is. There's very little law that says I have certain rights and privileges in the absence of a contract, right? And so unlike common stock or debt, which has 200, 300 plus years of established precedent to fall on, you don't have that with cryptocurrency. So especially in these ICOs that really sort of eschewed what I believe you really need to do, which is well document the terms and conditions and risks associated with that purchase or with that investment. There's no law that says I have innate certain privileges that would allow me to enforce a contract, enforce a written contract, enforce an implied contract. None of that exists because that law just hasn't been developed yet. So in the absence of a well-defined contract, right, that is determined at the time of purchase between the promoter and the purchaser, you're really left with a digital asset which is from a legal perspective barely an asset, barely has any sort of, from a legal backing perspective, any real ability to enforce any sort of rights and privileges with the counterparty. So, in summary, a smart contract, by virtue of its definition, isn't necessarily a contract. It's something to consider, especially when you're doing an ICO. Terms and conditions are a minimum. Some type of subscription or purchase agreement are an absolute necessity to protect yourself. And from an investor standpoint, in the absence of a promoter having those, I would shy away from those, because simply they may not be enforceable. And if there is something wrong where you lose your money, the project never makes minimum viability, whatever the case may be, you may be left with being in this sort of legal morass where you have no real rights and privileges to go back and try to recover your funds. So check me out, bitcoin-lawyer.org. I'm Adam Tracy. I'll talk to you soon.